This is Miki Matrician.
This is Amanda Brown.
We are attorneys at Chin & Curtis. We are pleased to provide you with this overview of the CAP H-1B process in light of the changes that are underway this year. Please note that this is a general overview of the CAP H-1 process and is not intended to be legal advice specific to your situation. Please consult your Chin & Curtis attorney with specific questions about your case. For those of you for whom this is your first time, here are some H-1B basics. There are three components to an H-1B. Number one, the job has to be one that requires at least a bachelor's degree in a specific field. For example, for a software engineer position, the minimum requirement has to be at least a bachelor's degree in computer science or related field. Number two, for you to qualify for H-1B sponsorship, you have to have the same educational background. Number three, your company has to comply with Department of Labor regulations. There are two requirements: the prevailing wage, which is set by the Department of Labor, and the actual wage, which is what other employees in similar roles are being paid at your company at the location. The wage is for the metropolitan area. So for example, if you are based in Cambridge, Massachusetts, it would be for the greater Boston area. What do we mean when we say cap H-1B? There is a numeric cap on the number of new H-1 visas available per fiscal year. This is a number that's determined by Congress, and there are 85,000 H-1B visa slots available. 20,000 of those are reserved for people with a U.S. master's degree. In the last few years, demand has exceeded the number of available slots, and USCIS has run a random lottery to choose the cases for adjudication. This year again, we expect that there will be a lottery due to the increased demand. Amanda will now talk about the process in past years and how it will change in this year's lottery.
The biggest change to the CAP H-1B process this year will be the online pre-registration system. In prior years, employers filed entire H-1B petitions during the first 5 business days of April. The government then notified employers of those cases selected in the lottery by email for expedited cases and regular mail for all others. Some individuals did not find out about selection until later in the summer, even as late as August. This year, the government has rolled out a completely new system that changes the notification timeline. So how will the pre-registration system work? The government will open the pre-registration system from March 1st to March 20th. During this time, employers will be able to register any individuals they plan to sponsor for a CAP H-1B. Importantly, any duplicate registrations for the same individual will be automatically disqualified. This means the employer will be registering you for the lottery, and you should not try to register yourself. Following the registration period, the government will then run the lottery and notify employers electronically of cases selected. Chin & Curtis will then work with your employers to notify you of selection. This notification is helpful because you should know much sooner than prior years whether you have been selected in the lottery. If your case is selected, there will then be a 90-day window for your employer to file the full H-1B petition on your behalf. So if your case is selected, the next step will be to prepare the filing. This includes collecting any updated documentation from you, such as pay statements or I-94 records if you have traveled. We will file the petition with the government and provide updates regarding the receipt notice, if there's a request for evidence, and of course, final outcome of the case. We do not yet know if premium processing or 2-week expedited service will be available for cases this year. In past years, the government has sometimes suspended this service. We will let you know if this suspension happens again. Miki will now speak about some strategy considerations for H-1B filings.
An H-1B petition can be filed in one of two ways. The first method is a request for change of status. That means that we are requesting that the H-1B status become effective for you automatically as of October 1st, 2020, if the petition is approved by that time. If your petition is approved later, like in November, your H-1B would become effective then. And what does automatic mean? It means if you are in F1 status, for example, As of October 1st, you wake up and you're automatically changed over to H-1B status within USCIS's system without you having to do anything. Change of status is critical for people who need cap-gap protection. I will talk about that in the next slide. What needs to be true for you to get a change of status is you have to be in the US when the case is filed, and in general, you can't travel internationally until after October 1. There are nuances to this rule, so if you have a question specific to your situation, please consult your Chin and Curtis attorney. The second possible method is consular notification. That means that your company is asking for your H-1B to be approved, but not activated until you take further steps. Those steps require that you travel internationally, apply for a visa stamp at the consulate, and re-enter the US. This might be necessary if you need to travel internationally while the H-1B is pending. It's critical that you have another underlying status that will bring you to at least October 1 or later pending approval. This also applies when you are outside of the US when we file the petition. Your Chin and Curtis attorney and employer will coordinate with you about the best strategy for your situation. So let's address who needs cap-gap protection and how you obtain it. You would need cap-gap if your F1 work authorization expires after April 1, 2020, but before September 30th, 2020. It is a way to automatically extend your work authorization to bridge the gap until your H-1B kicks in. If you are selected in the lottery, you would provide the receipt notice from the filing to your school for an updated Form I-20. You do not need to do a separate filing with the government for this benefit. Cap-gap is good only to September 30th. So if the approval doesn't come through by October 1st, you may still experience a gap in work authorization. Your Chin and Curtis attorney will coordinate with your employer if you are at risk for this situation.
If your case is not selected in the lottery, it's important to keep in mind that this does not mean your case was denied or refused, and it should not have any impact on eligibility for future U.S. immigration matters. For example, your employer may opt to sponsor you again next year for the CAP H-1B lottery. If this year is your last chance to obtain a CAP H-1B, again, for example, if your F1 student work authorization expires this year and you do not have other options, we will work with you and your employer on next steps. We hope this overview has been helpful to guide you through the basic steps of the process, and we look forward to working with you. Thank you.